Welcome to the Yale Cyber Leadership Forum, Criminal Law Enforcement Across National Borders. There will be a Q&A session at the end. If you would like to submit a question for the panelists, please do so in the Q&A panel. This session is being recorded. We will begin shortly. Thank you.
Good afternoon, everyone, and welcome virtually to Yale University's Jackson Institute for Global Affairs. I'm Ted Wittenstein, and we very much look forward to continuing the Yale Cyber Leadership Forum with today's session on criminal enforcement across national boundaries. We'll introduce our distinguished panelists, Richard Boscovich from Microsoft and Bruce Schwartz from the Department of Justice, in just a moment. For those of you joining us for the first time, this is the second of 7 bi-weekly Thursday webinars taking place this semester focused on sovereignty in cyberspace and bridging the divide among law, technology, policy, business, and academic communities on the most critical cybersecurity challenges. And unique to these virtual discussions, we have a great group of Jackson Institute and Yale Law students participating in the forum for class, interacting with panelists and practitioner fellows, and writing some reaction papers based on the sessions. As a reminder, all attendees have their volume and video muted, but we're eager to incorporate your questions. You can submit those using the Q&A feature in Zoom. And we're getting pretty good with names, but when we do move to Q&A, we ask if you are a fellow or a student in my and Ona's classes who are attending the forum for credit, just identify yourself as a reminder to us when you submit the typed question. And we're recording this session, and we will distribute and post the video afterwards for the benefit of everyone. We encourage you to follow along at cyber.forum.yale.edu, where you can view previous recordings, examine suggested readings, and check out the bios of our great fellows and students who are part of this vibrant program. The forum is a collaboration between the Jackson Institute and Yale Law School's Center for Global Legal Challenges, which is directed by my colleague, Professor Ona Hathaway. Professor Hathaway has been our partner since we first launched the forum in 2017, and we're so grateful for her engagement and visionary leadership. A widely recognized authority on transnational law, Professor Hathaway is an exceptional scholar and practitioner who's really been at the forefront of thinking about how international legal principles and norms translate to cyberspace. And as forum director, she's helped us design this stellar curriculum in addition to moderating the sessions. So we hope to see you again for our third session in 2 weeks' time, Defending Forward: Implications for Safety, Security, and Sovereignty in Cyberspace, featuring senior attorneys and policymakers from U.S. Cyber Command and the Department of Homeland Security. We're now in the 4th iteration of the Yale Cyber Leadership Forum, but a colleague who's been with us since the very beginning is Richard Dominguez-Boscovich, Assistant General Counsel at Microsoft's Digital Crimes Unit, where he leads the malware and cloud crime team. Mr. Boscovich is based in Redmond, Washington, where his team actively analyzes all forms of malware to include many of the botnets, ransomware, and Trojans that you read about in the headline news. A former federal prosecutor, he also develops legal strategies and technical countermeasures to disrupt these threats and protect Microsoft's customers, partnering with law enforcement agencies worldwide. And we're delighted to welcome Bruce Schwartz, Deputy Assistant Attorney General and the Department of Justice's Counselor for International Affairs. Mr. Schwartz supervises and coordinates the vast overseas operational activities of DOJ, including all extraditions and legal assistance in trans-border criminal and terrorism cases, many of which have a nexus to cybercrime. He's a graduate of Yale College and Yale Law School. Mr. Schwartz serves as the senior advisor to the Attorney General on international matters and represents DOJ on a wide range of sensitive bilateral and multilateral consultations. So it's a terrific group. Thank you so much, Richard and Bruce, for being with us. I'm going to let Ona kick off the discussion. And remember, please submit your questions using the Q&A function in Zoom. Thanks so much, and over to you, Ona.
Thank you so much, Ted, and thank you for your partnership. And thanks to both Richard and Bruce for being with us here today, and to all of our students and fellows and other participants. We're excited to see your questions. As Ted suggested, I'm going to open up with some questions first with Bruce and then with Richard. Just a few back and forth to get us going. That'll take us about to about 12:45, and then we're going to turn to all of your questions. So there's a Q&A button at the bottom of your screen. Please go ahead and type in your questions. You can go ahead and type them in as soon as they occur to you, and we'll be keeping an eye on that. And Ted will pose those questions when we get to around 12:45 or so. So I want to pick up, Bruce, where Ted's introduction left off. So as he said, you're the Deputy Assistant Attorney General and Counselor for International Affairs at Department of Justice. Can you say a little bit about how the department is organized to respond to cybercrime? What does it do? How does it do it?
Well, thanks, Ona. I'd be glad to. And Ted, thank you for putting this together as well. My real responsibility is to be blamed for whatever happens internationally at the Department of Justice. But in order to disperse that blame, we have a number of different components that work on the cyber issues. So, of course, in thinking about this, there are really three dimensions, at least three dimensions, probably well beyond that, of the cyber criminal issues. First, there's the state-sponsored cyber intrusions. And then second, there's true cybercrime, that is crime that involves computers in the sense of theft of computer data, ransomware, computer intrusions. And then finally, there's a separate problem, and that's the problem of electronic evidence, evidence that's stored on our servers here in the United States or elsewhere that may have nothing to do with a cyber crime per se, with actual use of computers to commit a crime, or with computers are actually the target of the criminal activity. So all of those dimensions play across the range of what we do. In terms of the first two categories, in the state-sponsored and standard criminal cyber activity, we have a computer crime and intellectual property section. As Richard knows, at the Department of Justice, it really is the central organizing entity for the prosecution of cyber crimes, but we also have representatives throughout the U.S. Attorney's offices, specialists in cyber criminality. The FBI, of course, has a similar cyber unit organized to deal with this. In terms of our international relations, the Office of International Affairs is the central authority for the United States. It is the treaty authority both for extraditions and for mutual legal assistance. So all incoming and outgoing extradition and mutual legal assistance requests, including in the cyber context, come through the Office of International Affairs. And that's true regardless whether it's the Department of Justice, Homeland Security, or state or local governments. It's a unique office in that regard, in that it looks to not only the federal, but the state and local level. So within that Office of International Affairs, we have a specialized unit that deals with, in particular, cyber matters, incoming requests involving cyber evidence in particular. And of course, we are also processing the outgoing investigative requests from the United States. That's just a short synopsis of how we organize this, but it is obviously an increasingly critical part of what we do. I think it's telling that I think it was in 2008, we had 9 mutual legal assistance requests involving electronic evidence. And now, of course, we're in the thousands every single year. So I'll leave it there, but glad to go into more detail.
That's great. So I'm sorry for the phone call. I meant to turn that off beforehand. So I want to dig into each of those categories that you laid out, because I think they're each incredibly interesting and obviously of great importance. Starting with the first that you noted, so state-sponsored activity. And you mentioned, nation-state activity in this space is a central concern for the U.S. government. I wonder if you could say a bit about the role of DOJ there. So, Russian cyber activity, malicious cyber activity has been a focus of significant news around the election. There's also, of course, been a number of high-profile incidents involving the Chinese. And DOJ, I know you can't speak to specific events, but just for our students and others who are listening, DOJ has played some role in responding to those events through putting in place indictments against known individual Russian and Chinese hackers who've been identified as having been involved in these events, which are likely state-sponsored events, but obviously criminal activity has to be criminal responsibilities directed against the individuals who are known to have participated in it. I wonder if you could say just a little bit about how DOJ sees that part of its role in responding to state-sponsored malicious activity, and the way in which indictments figure into the kind of whole of government response.
Right. No, I'd be glad to. And there's obviously limits to what I can say in this regard, and I can't say anything more than we've publicly disclosed. But one central aspect of the actions we've taken of the proceeding by criminal indictment is to make clear that there will be consequences for this action, and to also make clear that despite the seeming anonymity of the internet, we can make attribution. We can make attribution to individuals. That, I think, is an important message. It sends, we hope, a deterrent message for future hackers. It certainly sends a message to those that are charged and identified. I think it's, to quote some of our prior statements, we have been relentless in trying to track down cyber criminals. That's not just in the state-sponsored context, but we will seek to locate individuals if they travel from their home country to third countries, and proceeding through Interpol red notices and other options available to us, seek their extradition to the United States. In fact, Foreign Minister Lavrov of Russia several weeks ago, in one of his speeches, commented on our policy in this regard. Russia does not favor that policy, I should note, but we do think that it sends a powerful message and does ensure that justice is done with respect to these individuals, that they come here, they receive, of course, appropriate trial with all due process guarantees, but they will be convicted if they committed the crimes of which they're accused. And I think that message is one that's important to send. You simply can't let this conduct, whether state-sponsored or private, be seen as something that can be done in one sovereign jurisdiction and not face consequences in the other.
Can you say a little bit, and maybe this is getting a little bit beyond the ambit of your purview, but how DOJ sees these indictments as fitting in as compared to other kinds of US government responses? So, obviously there's sanctions, there's diplomatic responses, there's cyber defense, there's this new active defense or defend forward policy. How does DOJ kind of see this as fitting into the broader picture? Is there a kind of whole government conversation about that, or is it just this is a piece of the pie that DOJ can really take on, that is identifying and sort of making clear we know what you've been up to, and it's not necessarily sort of coordinated or connected to these other kinds of responses? You'd say a little bit about how those fit in?
Well, much as I would like to say this is the best part of what we do, that would simply not be the case. It is, as you say, part of a coordinated approach. And in this sense, I mean, we do make our prosecutorial decisions independently. It's not that we consult or do this as a foreign policy matter or otherwise. These are driven by the facts of the case and the law. So we are responding in that context. Nonetheless, when we do bring such prosecutions, it does allow other tools the U.S. government to be brought into play, including sanctions, as you say, including diplomacy. And of course, the end game here is not just the individual prosecutions. We want to make sure that first, at the most basic level, there aren't safe states, there aren't sanctuaries for these individuals, so that countries around the world will move collectively against cybercrime. But beyond that, we also see it as the basis for diplomacy to try and change the way that countries approach this. And we, of course, have been at the Department of Justice, along with other departments, including Department of State, proponents of trying to build out an international legal framework, in particular through the Budapest Cybercrime Convention, precisely for that purpose, to have a common understanding of what activity is criminal and what activity is permitted, how we investigate those crimes, and a common understanding of the range of cyber criminality. So prosecution is just one approach, but in many cases, it is the approach that's most likely to bring justice, particularly when we're talking about situations where individuals have been victimized by cyber criminals.
So that was the sort of the next piece I wanted to pick up on is the role, sort of you laid out state-sponsored activity as sort of one, then sort of standard or sort of true cybercrime. It's sort of the person who tries to steal a bunch of social security numbers to be able to use them to open accounts, or who infiltrates a bank in order to take money, sort of this sort of standard cybercrime, not necessarily state-sponsored. Can you say a little bit about what the chief challenges are that you face there? And obviously, you're working with private actors who are generally the victims of these crimes. How does that create challenges in addition to the kind of international global scope of the problem that might be generally the actors who are engaging in these criminal activities, I assume, are for the most part located outside the United States. So what are some of the kind of chief challenges that you face in those efforts?
Well, and Richard, I know will want to address this too. We certainly do count on the partnership of many in the private sector, particularly in making us aware of criminal activity that targets corporate entities. In terms of the obstacles, it's exactly as you suggest. The standard obstacles of international investigations, compounded oftentimes by the complexities of cybercrime, in particular, not knowing always, at least at the outset, where the criminal activity originates. But I think it's striking, and if you look at some of our recent cases, NetWalker, Emotet, others, just the kind of international coalitions that we've built to deal with these, and the kind of coordinated takedowns that take place. Europol, the police organization of the European Union, has been an especially important partner in coordinating many of these actions. And I think that sends in itself a very powerful message. When you have not just the United States doing a prosecution or a series of arrests, but around the world, servers being seized and individuals being taken into custody for trial, that does send the clear signal that you cannot expect that you have impunity for these offenses. So that's been a major portion of what we've been doing. And we have, to that end, we've detailed numerous personnel to counterparts around the world, including at Europol, where we have both cyber prosecutor and FBI agents. And Interpol itself, too, also plays an important role in this.
So I wanted to pick up on that line, sort of the global cooperation piece of this. So you've mentioned a couple, you've mentioned Europol and Interpol, the Budapest Cybercrime Convention. What do you see as kind of the next step in terms of global cooperation? Sort of what do you see as kind of what would you want next, in addition to sort of, you've already mentioned the ways in which this kind of global cooperation has been helpful in addressing the kind of challenges that you face, but sort of, if you could wave a magic wand, sort of what would be the next step that you would wish we would engage in, or what do you think you would recommend to American diplomats who are thinking about kind of trying to move diplomacy to better further your work? What would be the kind of next steps that you think would be particularly important to focus on?
Well, aside from world peace, which of course we all wish for, I think the most immediate task before us is going to be the negotiation of the UN Cybercrime Convention, which will begin this spring, and ensuring that that does not become an instrument that is injurious to a free and open internet, but we hope will mirror what the Budapest Cybercrime Convention does, which is both to establish the range of criminal activity and to make clear the mutual legal assistance obligations. I think in terms of the obstacles we face, and I'd be interested in Richard's view on this too, it's really the border nature of evidence and the problems posed by what we can term cross-border searches. And that really is the area where we have the most complex set of issues. And they range from issues we addressed in the Cloud Act to data protection concerns in the European Union and elsewhere. And working through those has been critical. In terms of the cross-border search aspect, of course, the Cloud Act is, we think, a very important step forward. It really does create a different paradigm of thinking about where, who has the authority to obtain evidence without having to go through mutual legal assistance. On the data protection side as well, we're trying to see if we can work through these issues. I mean, one of the curious and little recognized facts is that electronic evidence stored in the United States, whether it's from Europe, Asia, or elsewhere, has a higher level of protection from criminal process than almost any other place in the world. And one of the things that drove the Cloud Act, again, paradoxically, given the general view of US data protection standards, is that our counterparts, particularly in Europe, but elsewhere, had a difficult time and continue to have difficult times meeting the probable cause standard to obtain the content of electronic evidence. So moving forward on the Cloud Act paradigm, working through the data protection issues that we've been discussing in Budapest and elsewhere, I think those will be the central issues. And again, they all tend to focus around I know the first topic, the internet is everywhere and nowhere. The question is who and which country should have jurisdiction over these matters.
Well, that brings me to sort of your third category, the sort of data, sort of access to data evidence, electronic evidence around the world. And one thing that came up in the first session, which you mentioned, data is everywhere and nowhere, is this increasing move from some states to insist on data localization requirements. Are you finding that that has become an issue for the work that you're doing, or do you anticipate that becoming an issue for work that you're doing? How is that going to factor into your thinking around the ability to obtain and also requirements for providing electronic evidence?
So I think it could become an issue, and I know it really is the central point. And of course, when I was with you on the panel when we did this before the Second Circuit on the everywhere nowhere point, I don't think I got kicked off that because I said I knew where the internet was, but it is the case that if you look at the mutual legal assistance requests, both incoming and outgoing, what's striking about it in the electronic evidence category is that the vast preponderance involve electronic evidence, not cybercrime per se. That is not crime directed at or facilitated by computers. So we find ourselves in this curious position in which evidence has really been dislocated. So we talk about transnational crime. That's what cybercrime usually is. But then there's what we can call transnational evidence, evidence that could be a murder in Germany, a stabbing in Sweden, a bank robbery in Ghana, that has nothing to do with the internet, but the phone records that might be relevant, the cell phone records, or communications with respect to text messages or planning. That's here in the United States or in some other jurisdiction. So I think it's roughly a fifth of the requests that are incoming are for true cybercrime, with the vast preponderance, the 4/5 of them being about electronic evidence. And outgoing too is disproportionately about electronic evidence. So we find ourselves in a situation where data localization might seem like an attractive alternative, except even then it's not clear that you really could accomplish what you would want. That is, for some policymakers, it might seem. I think it would be a disaster for the internet. Richard can talk about the business model for Microsoft if they had to deal with that. But I don't think the answer is localization. I think the answer is more along the lines of the Cloud Act, with a recognition that as long as we're a set of countries, as the Cloud Act presupposes, that have fundamental guarantees of due process and civil liberties protections, that evidence that doesn't have anything to do with the country where the information is stored should be available to the country where the crime was committed according to their standards. That I think was really the genius of the Cloud Act. And I think that's a much more attractive way of proceeding rather than trying to cut up the information, which we've seen already. I mean, in this kind of thing, just given the way information is stored, it can be subdivided, and it can be in many different locations. So even for the same fundamental set of records. So I think that's really what we need to be thinking, and I think this is the central challenge for us. How do we ensure that we have an open internet, that we can conduct investigations, but that we're not putting civil liberties at risk by doing that?
I think that what you just said gets to such an important point, and to sort of our broader theme of sovereignty, the challenge that you face here of, you know, who gets to make the rules. You know, so the Cloud Act sort of decides to address that problem by saying, you know, if you're the country that needs the evidence for criminal prosecution, then it's your rules that govern the taking of that, or the getting control over the evidence that you require in order to prosecute. And that makes a lot of sense. It does mean that the country that holds it might say, well, you're not meeting our standards when you're taking that information. And so, you know, we have, as you said, probable cause standard, which is generally higher than many other states. So should we apply our standard to the evidence before we hand it over, or do we hand it over even if it only meets their standards? And so just for the students who are on this conversation, so just one really great example of, you know, somebody's got to give, right? So you've got to come up with a set of rules that allows, that resolves this question, because if you try to apply everybody's standards, you're going to end up not being able to get anything done. Particularly, as you pointed out, this evidence might be stored in 50 different places. You know, the relevant information, the pieces of it might be in so many different places that if a prosecutor has to negotiate with every single one of them, it's just going to be impossible to do their job. So these are the kinds of challenges that we face.
Right, and you're right. And of course, as you know, the United States is fundamentally a giving nation. So we're just, you know, we're all about helping other people, as I think everyone acknowledges. But the Cloud Act, it really, what is striking about it, as you know, is that it would mean that a country doesn't have to meet the probable cause standard, as long as it's really in many ways a comedy-based approach, and a recognition that our close allies and those that would be joining the Cloud Act, that we can count on them having legal systems that protect rights, maybe not identically in the way that the United States does, but nonetheless are sufficiently due process oriented that they don't have to prove that this particular computer was used in the probable cause sense that we would have to do. So that's really the way forward, we think, and it will certainly be, I'm sure, an ongoing issue, including at the UN negotiations.
Absolutely, there's no doubt about that. And I think that that's a really important clarifying point, which is the Cloud Act. You apply this sort of, we'll let you apply your rules, not apply our rules, but only with a subset of states whose basic due process of law, rule of law standards you trust. And so now that makes a ton of sense, but that then of course means you're only able to get access, that you only have that reciprocity with those countries that are within whose standards you accept and who accept your standards. So it does kind of have this kind of club element to it, in that this group of countries is going to agree, but there's of course going to be a number of countries that are going to be outside of that.
And that's right. And I do remember Attorney General Reno once saying that she hated clubs. But the good thing about this is it doesn't, that process speeds the production. It doesn't preclude non-club members from getting the evidence. They simply go through mutual legal assistance. And that's in itself an important check. I mean, even in the Cloud Act, we have to be building in assurances and protections for First Amendment conduct, because a lot of requests we get do raise some of those issues. And we want to make sure that we are protecting the individuals whose evidence is being sought if they're not proper requests. I mean, there's certainly no easy answers, and you're right. If you're not a club member, people want to say, well, still we need to localize data. But I think that from a technical point of view, and again, Richard can speak to this, the idea that you could actually localize data is probably not feasible in a complete sense.
Great. Well, this has been so interesting, and we could keep going forever, but I want to make sure that we have some questions for Richard and then open it up for questions from the audience, because I know that they're going to have a lot of them for both of you. So Richard, thank you again for being here with us as our most repeated member of the forum. We're so glad to have you back again. So I wonder if you could just start off as we did with Bruce, just sort of saying a bit about what it is you do. So people may not have heard of the Digital Crimes Unit at Microsoft before. So you can say a little bit about what the Digital Crimes Unit is, what it does, and how it operates in coordination with countries around the world.
Sure. Well, thank you for having me again. It's always a pleasure participating in these. I love the interaction with the students in particular. Well, the Digital Crimes Unit is one of the unique aspects of the DCU, really is the cross-disciplinary approach and the people that form the DCU. So when you think about the Digital Crimes Unit, you're looking at not only engineers, data analysts, policy folks, but also attorneys, all working on a very complex issue and problem for us, which of course is to protect our customers. The core folks are in Redmond, Washington, so a lot of our engineers are in Redmond, but we are a team that cuts across all jurisdictions. So we have attorneys and technical folks in our EMEA region, which is Europe, Middle East, and Africa. We also have teams in LATAM, South America, Central America, and the Caribbean, as well as in APAC. So we do have an international reach, which helps really in the investigation, and we're trying to map out our next targets. The way we operate, our number one objective has always been to protect our customers. That's what Microsoft wants to do and has spent enormous amounts of money and technology on trying to do. So our mandate is to work with our enterprise customers, work with consumers, working with other internal groups in Microsoft that we call the product groups, that are the customer-facing groups like Azure, Windows Defender, Office 365, getting telemetry from them and understanding what the threats are, and then evaluating which threats we believe are the ones that we should go after. And when I mean going after, I think this is really the main difference between what a private company such as Microsoft does and what Bruce described from a nation state or DOJ, for example, is that our objectives really are to understand the infrastructure and then to stop the harm, notify, and remediate. So that's an important part, because a lot of the things that you were discussing with Bruce goes really to evidence and attribution. Attribution for us is not as important as the remediation and the actual protection of our customers. So the type of evidence and the type of things that we seek, for example, to obtain, many times, especially now which are overseas, are of a different category of what, for example, DOJ would be looking for. Things that are in servers or things that are in email content, we don't need that content. We look for hashes, command and controls. So the legal standards are different. And in a way, leveraging our folks overseas to be able to obtain this information is unique and different from how the government has to do it.
So can you take us inside a particular event just to give folks a kind of idea about how you actually go about doing this? So I know that you worked to take down the so-called Bot Malware, which was a Trojan that infected Microsoft Windows operating system, and that led to the theft of banking details and other credentials. So can you take us through kind of how does that work? How do you identify that? And then sort of what are the next steps?
Okay, generally, how do we pick a target? I mean, really, that's the first step. And as I mentioned previously, we really sit back. We work a lot, for example, with industry and enterprise customers and ISACs. In the case of TrickBot, we work very closely with FS-ISAC, which is basically an association of banks and their security personnel. and working with them to see, well, what's impacting their customers. And they provide us information as much as they can within their regulatory framework. And TrickBot came up as one of the major causes of banking fraud and exfiltration of tens of millions, if not hundreds of millions of dollars. So once we identify a target, we then go back and we start analyzing the telemetry. And one of the great things about working at DCU and Microsoft is we could go outside of DCU for Windows Defender. That means we look at the telemetry that we're able to gather from our AV products to see, hey, is this actually impacting our customers at the same rate that the banks are saying are impacting their customers? And if the two come back saying, yeah, it's a big problem for our customers, the next step is, well, let's do a critical analysis. And that's where the engineers come in. So we spend an inordinate amount of time of doing reverse engineering. And in many instances, in TrickBot, for example, we rely on public-private partnerships. On the private side, I mentioned we do work with our own AV folks and our own engineers, but we also work with many times competitors. ESET, which is a Slovakian AV company, was on the team. We work with others such as the Black Lotus Labs, NTT, also working with us and looking at the code, reviewing the code, and giving us an idea so that we could map out the infrastructure. So that's really the first step. You have to kind of pick the target, validate the information that you're receiving, that it is in fact a threat, and then reverse engineer the malware so that you could then map out the infrastructure. Once you map out the infrastructure and you're able to understand where the infrastructure is hosted, and this is where it gets very complicated, then you have to decide, well, how do you go about doing the actual disruptive action? And what we've seen over the past decade, when we started this many years ago, is that the bulk of the information, or the infrastructure, the servers, the domains, were primarily in the United States. It was a very good and resilient, infrastructure. Criminals want that too, but they catch on, and it's extremely dispersed now. So we have to now develop a type of, strategy so that we're able to disrupt it. But it gets complicated because as a multinational and a private company, it has to be done in a legal fashion, which doesn't violate the laws of any jurisdiction where we do business and where the infrastructure is located. So that's the steps that we go to just before we start the legal analysis. And then we go ahead and prepare the framework and see, okay, what are we going to do? And it takes a lot of time. But in the TrickBot case, we developed a completely new set of legal principles on how we executed the case legally in the US, vis-a-vis how our DCU colleagues overseas executed the operation of disruption in their jurisdiction at the same time we did ours in the United States.
Can you say a little bit more about how you work with different nation states? So you mentioned, now the infrastructure is extremely dispersed, that these cyber criminals are operating from lots of different countries, probably tend to be working in more permissive countries, or those that they perceive in that way. So how do you engage with nation states abroad? Sort of, what do you do if you say identify someone who's located in a given country who's a source of malware that's having a significant impact, and you think that the nation state might be friendly to addressing the problem through criminal jurisdiction? Like, how do you work with them? How do you approach them? Do you have ongoing relationships? Like, how does that just functionally work?
Well, I mean, so I mentioned that we work with private partners and public partners, and TrickBot's a good example. Once we identified the threat, we mapped it out. We then go, okay, what can we do, again, on the remediation, notification with the disruption aspect, and what part of that goes to law enforcement, goes to the public sector? And in fact, in TrickBot early on, we did a criminal referral. And as Bruce mentioned earlier, it went both to DOJ and also went to Europol's EC3, which have been tremendous, partners globally in terms of these enforcement actions or disruptive actions that we execute as well. So when it comes to that part, in terms of the attribution part, that is really something that goes over to the law enforcement side. On our side, the unique challenges we have is what happens when you have servers, which are the command and control for the malware, for example, which is located overseas. So what we have to do is, what can we do within a civil framework in those jurisdictions to be able either to take down that server or to access that server? So we were very creative, and basically we had our lawyers in EMEA, in LATAM, and in APAC replicate what we were doing in the United States to be able to do one of two things: either have a notice and takedown to take down a particular server, and or if it was within the powers or within the legislative authority to do so, to be able to then take over that particular IP address to be able to see the traffic, but from a remediation and notification aspect. So it's a little bit different. So the attribution is really the province of the public sector, and our focus with our private partners is in the actual infrastructure itself. So we rely on civil law overseas as well as domestically.
So I want to take you to another incident that's been much in the news of late, the SolarWinds intrusions of US government and private sector networks, which some had attributed to Russia. So we hosted Microsoft President Brad Smith for a conversation over the summer. And he said that these intrusions were not espionage as usual, but rather an international assault and reckless and broad endangerment of the digital supply chain and our most important economic, civic, and political institutions. I wonder if you could speak a bit to that. Sort of what is it exactly that makes, you may fill in our audience a little bit more on what SolarWinds was, but what makes that kind of breach so threatening, and what distinguishes this attack from other kinds of sort of, I don't want to say run-of-the-mill cyber criminal activity, but more or less run-of-the-mill cyber criminal activity or espionage activity? What was so damaging about SolarWinds?
I mean, first of all, I think, Brad did a great job in explaining it in two locations. One, of course, was his blog in December. I know he spoke there in the summer. Then there was a blog in December that kind of really outlined the SolarWinds issue, and I believe he also had a piece with Kara Swisher podcast with the New York Times, which actually kind of discussed SolarWinds as well. And I think the point that Brad wanted to make and made, I think, is that it really attacked the actual supply chain in a way that we have never quite seen before at this scale. And it attacked the supply chain, which really is something that elevated the type of attacks. It changed the game quite a bit, and how these cyber criminals are acting and really going after the very backbone of the infrastructure. Now, we've learned a few things as a result of that. One of the things that I thought was fascinating as I started looking into SolarWinds myself is that type of supply chain attack is what they basically did is they went in and they compromised the company by some traditional means. Either a password spray or some sort of phishing attack. And once they got into that company, the on-prem aspects of their infrastructure, they were able to go ahead, move laterally within the company, and then were able to get into their product, which was then which updates, literally thousands and thousands of computers around the world. I think Brad mentioned there was about 17,000 known victims. That's a substantial 17,000 known victims so far. And it went up into that supply chain, and it just propagated throughout the supply chain. Now, the interesting aspect of this attack, and I think right now, as the experts have noted, is more likely than not a nation state, was that this technique, and it kind of occurred to me, I had seen it before. The way the authors, going back to TrickBot, had managed their malware was very interesting, because what you see in SolarWinds is that once they infected a multitude, it was like a shotgun approach, just infect everybody, and then we'll do reconnaissance later on. And then they start picking and choosing the actual victims. And I think that's where you see, well, this is really targeted, depending on the victims, that it's probably a nation state attack. But that type of, infiltration and then reconnaissance, we've seen it in the crime for profit model as well. In TrickBot, it started out as a banking Trojan, but it was a very modular system. In other words, they could send out new modules in the malware to do different things. And what we noticed, and this is one of the reasons why we actually picked TrickBot as a target as well, is that they pushed up what they call a reconnaissance module. And what that meant was that they would now go back to the thousands and thousands of computers they infected and have already victimized by way of the banking Trojan, do a reconnaissance mission, literally look at CPU, type of operating system. Is it a small business? Is it a hospital? And then reintroduce ransomware attack. So that type of tactic that we've seen in TrickBot is not that different from what we're seeing in SolarWinds in terms of going in and then doing the reconnaissance once you're on the box to go ahead and victimize that particular box. The other big problem with SolarWinds, and I think this is what, again, going back to Brad's statement that, hey, this really is something that is an attack on the very supply chain, is that you don't know the quote unquote unintended consequences of what you do. It's kind of like a blast radius. If you throw a bomb, you know exactly what the blast radius is. And so you make sure you're outside of the blast radius. But what happens if it goes awry? If something happens in that code that does something, there's more damage than even the bad actor has intended to do. And all of a sudden, that negative consequences, it goes out of control, and it's throughout the entire supply chain. And I guess you could think about the food supply chain. Imagine you start doing one thing, and then before you know it, you've like literally impacted the world's food supply chain. It's kind of like the same analysis. So it's a very dangerous attack. But the one thing the positive aspect, at least from Microsoft's perspective, I think, looking at this, and I think Brad also was really honed in on this feature, on this point, was that when it happened, it happened on-prem, and we didn't have any visibility because we don't have visibility on-prem. But once it moved into the cloud infrastructure, right? Because once that code, which now had that malicious payload, goes into Azure, for example, then we have visibility and we're able to detect it. So if you think about it, it really underscores how the supply chain is only as strong as its weakest link. We picked it up once we're ready, but you have to be, prepared, and you have to be very cognizant of what your security protocols are when you have an on-prem system. So things like, dual factor authentication, and making sure that the keys, for example, to your cloud accounts, be it whatever cloud service provider, is not openly stored on your on-prem system. Because once they get access to your on-prem and they go ahead and move laterally within the organization looking for the admin, for example, they get the keys to your cloud, then they're inside. And then, of course, once there, we're able to identify the malware. But that really was something, the takeaway of the story is, the supply chain is vulnerable, but you have to make sure that your on-prem systems are secure and that you have to treat your passwords and access to other cloud assets very carefully.
Well, it's definitely a message that we've heard in previous sessions of both the kind of fact that you're only as strong as your weakest link, and with supply chains, if you're working with suppliers who are not using strong cybersecurity measures, even if you're doing everything right, you have a vulnerability by virtue of their vulnerability, and that makes it especially challenging. I understand for private actors who are trying to manage this what seems to be a kind of growing vulnerability to cyber attack. My final question for you, and I encourage your audience to go ahead, if you haven't already, add your question to the Q&A. There's a little box at the bottom of your screen. If you click on that, it should open up a window that allow you to type in your question. So sometimes when we have these conversations, we get to this point where we see like so much vulnerability of private actors, it can put their whole business model at risk, that there's so much cyber activity out there that really is quite dangerous. Some of these private actors, their response is they want to be able to hack back. They say, look, if government isn't going to hack back, we want to be able to sort of go after the bad guys ourselves. Can you say a little bit about how you think about that, and whether that is a good or a bad idea, and if so, why?
The whole concept, we've been hearing this for a long time. It's time to hack back. I think there's even there are some companies actually that have specialized in like selling some products also in hacking back. This is a very dangerous road to go down. And the reason being is that you don't want a situation where, like I said, unintended consequences, no good deed goes unpunished. You do something, and then before you know it, especially, for example, SolarWinds, imagine if you hack back, you put some code out there, and that code is then, the blast zone goes way beyond what you've intended. And then you have all of this collateral damage, innocent computers going down, God forbid, hospitals going offline, and so forth and so forth. So what we believe is that, when we started this program, we have to make sure that, number one, it has to be legal. So I like to look at the legal structure, and the way I view it is, well, look, if there's a statute that's out there that allows a private plaintiff to protect itself, then the other traditional rules of civil procedure and process are going to ensure that only the people that have, quote unquote, skin in the game, I think lawyers call it standing, will be the ones that would engage in this activity. Because you know that the person with standing, the entity with standing, is going to do so responsibly, and with the understanding that, hey, you are exposing yourself potentially to civil liability and counterclaims if you do not act appropriately within the context of the law. So our position is, we believe in an active defense, but an active defense which falls within the parameters of the law in the jurisdiction or jurisdictions in which you're acting. And it's been very successful. But you have to have standing, because you have to have that legal authority and interest to be able to do something. I think that simply deputizing companies to go out and do things is a big mistake, and it's very dangerous.
Well, as you may have guessed, I agree with you on that. I guess Bruce would probably want us to add that it is also in violation of the Computer Fraud and Abuse Act for private companies, at least located within the United States, to go out and hack back on their own. But it seems like every time we have this conversation, nonetheless, the idea comes up. So I wanted to make sure that we had an opportunity to talk about it. So I'm going to turn it over to Ted, who has been watching the Q&As closely and is going to pose some of the questions that we've received from our audience. So over to you, Ted.
Thank you, Ona, Richard, Bruce. This has been a great conversation. We'll try to get to as many of these questions as we can, or at least some of the common themes that have emerged. And I'm grateful for all of you for spending time with us. One of our kind of initial questions here is from Gang Zhou, who's one of our fellows. He's actually the legal director at Verisign. And he's asking about sort of, I'll put this to you, Richard, sort of best practices for multinationals dealing with possibly questionable requests from foreign jurisdictions. So this is, for instance, in China, we've seen some reports of, requests to multinationals that might be, in line, not in line with how we might think about civil rights or civil liberties. So how would you deal with that? Or potentially, would you approach the US government? Would you come up with legal grounds to resist a request like that? Particularly, or I would add to this, multinationals that may be not as well resourced or connected as Microsoft for how they might go about elevating a request like that. Just give us a sense of some of your challenges in some of these more authoritarian governments.
Well, that really, that's a great question. That is really outside of my area of expertise. We have a department in Microsoft called LENS, Law Enforcement and National Security. They deal with all the subpoena requests from multiple countries. And that process is extremely detailed, and we have a very, mature process in dealing with these types of issues. What I can say is that I know, and unfortunately this is as deep as I can go because I'm not involved in the day-to-day operations of that unit, is that there are certain jurisdictions in which I know for a fact that the legal request would not necessarily be complied with. Now, the parameters under which, when they are and they are not, I do not have that information. Again, that's something that's really within the LENS team's purview, and I don't have much information that I could share simply because I don't work in that area.
Thank you. That's helpful, Richard. And of course, we understand Microsoft's a large company. I might just put this back to Bruce because we also do have a number of China-related questions that might be relevant here. One is from one of our law students asking about, how we consider even the possibility of cooperation with China, given that we have, aggressively, indicted for criminal behavior, elements of the Chinese state. Is it possible to think of some form of cooperation with China in this area, or is this primarily an adversarial relationship, from your perspective? And I guess a little bit more broadly than that, we have a question here from a Jackson student that's asking about sort of, are we creating sort of two sort of separate spheres of internet governance in this area? Is it sort of the US, Europe Cloud Act, Europol regime, and a new entity of sort of Chinese influence? Is this something that factors into how DOJ thinks about this, or is that a sort of broader geopolitical consideration?
Well, thanks, Ted. I actually lost the visual here, so I'll assume that's not malicious state activity directed against the Yale cyber.
I'm aware of.
But as long as you can still hear me. So I think the Biden-Harris administration has made clear and their intention both to work with other countries and to counter malicious activity without making it China specific. That is the goal, to try and find points of commonality, to try and move countries towards norms of behavior and to recognize norms of behavior. So with countries around the world, even countries that we have serious disagreements with, we do have, in some instances, law enforcement cooperation. It depends on the matter. It depends on sometimes just the transactional nature of a country needing assistance from the United States. But we are committed to trying to establish norms in cyberspace as we do in other criminal contexts. That's one of the reasons the Budapest Convention is so important, because it does create a set of norms. And we hope that the UN Cybercrime Convention will do the same. We certainly don't want a divided internet with different spheres of influence, nor do we think there should be such an arrangement, since we believe that the rules that we would apply, and not just the US rules, but the types of rules that we've all agreed upon in the UN Transnational Organized Crime Convention, the UN Corruption Convention, the rules that build really a framework for international criminal justice cooperation should apply in the virtual world no less than they do in the real world. So our goal is to try and change behavior, not just for change in behavior's sake, but to actually encourage countries to rethink the idea of protecting cyber criminals, making use of cyber criminals for state purposes, making use of cyber to engage in economic espionage or malicious interference with the activities of other countries, and to work collectively then against cyber criminality by individuals within countries. It's not as if we don't have cyber criminals too in the United States. So we're not suggesting otherwise. The important point is that we all have a collective response and that we all treat this as serious a type of criminality as it in fact is.
Ted, I would like to add one thing if I can. I'm not sure if you can hear me or not.
Yeah.
It's interesting to note that back in 2010, and this goes somewhat to what Bruce is saying, when our first operation in Walladack, we actually were able to secure excellent cooperation from the Chinese CERT, CN-CERT. What we had identified is the command and control structure. There were domains that were being leveraged that were hailing from that country, and there were victims there as well. And one of the necessities, since it was beyond their jurisdiction, we could not take down those domains. It's outside of a US court order, obviously. We could address the domestic domains, but we couldn't address the ones that were overseas. So we reached out to China CERT, explained, provided technical information, and in fact, those malicious domains were taken down at the same time that the other domains were taken down. So it really assisted in the effective takedown of that particular malware infrastructure back in 2010. And we did have a follow-up with them, I believe it was in 2011. So especially when you identify victims inside of China, I mean, there is a way to get cooperation from them, trying to go ahead and assist in protecting consumers globally by having them jump on board and cooperate at times.
Thank you, Richard. I'm glad we got some China comments out of you on that question after all. Related to that, Richard, we have a question here from a law school student, James Fitch, who's asking about, do you ever have kind of conflicting interests between both granting access to a foreign jurisdiction and how that might impact your customers, but at the same time, you might be requesting access from a foreign jurisdiction in the course of your own investigation of cyber criminal activity. So, as you investigate digital crimes, how do you think about this potential trade-off for the precedent you may be setting for that country or another country to then be requesting data from you that might impinge on privacy or other elements of how your company might think about your customer privacy?
Again, you have to have an understanding of what type of information or we're actually trying to obtain. And it goes back a little bit to what I had discussed in the opening, is that the information that we need and that we have to quote unquote obtain is very different from what, for example, a criminal investigation would need. We're looking really at things such as malware hashes. We're not looking at content. We never look at content. So it really is, hey, we go out and ask, either legally or simply based on business relationships. Look, there is a particular server which is hosting malicious content. We're not asking for the content. What we're asking for is that party, for example, if it's just a informal request, look at what's happening and take that server down. And you'd be surprised that in many, many situations, that company, generally it's a company for profit, it has a reputation, they will take that information down. So we never look for the content, so we don't really have that problem or that issue, because what we're doing basically is, look, this is something that's impacting consumers globally. We need your assistance to clean up the internet, and everybody's looking at you now because you're hosting this. What say you? And they tend to go ahead and comply with that. So we don't necessarily go for content. We go for taking down infrastructure, which is very different than what a criminal investigation would mean.
Thank you, Richard. Bruce, we have a question from another law student here about sort of the post-incident regulatory environment or changes you might think about in the aftermath, right? So one is investigating and prosecuting the actual criminal behavior. And just an example of SolarWinds, there may be some questions here about the vulnerabilities of supply chains or the liability of certain entities or individuals for negligence or other activities. How does DOJ think about these sort of ex post regulatory questions as well as sort of the immediate prosecutorial effect? Are these different actors within DOJ? Is that something within your purview? Is it, how do we sort of get not just focused on the immediate question, but see the broader picture as ways that could enhance cybersecurity long term?
Well, the National Security Division at the Department of Justice, which leads on the cyber-related aspects of hostile state activity, does think broadly about all of these issues. It's deeply involved in the front end, if you will, thinking about supply chain and supply chain security and cyber defense, working with DHS as FBI does as well. But in the aftermath as well, I think it's fair to say that's a completely cross-government activity in which DOJ participates. If Deputy National Security Advisor for Cyber, Neuberger, yesterday gave an extended statement at the White House press briefing about SolarWinds and really the three aspects of it, which is, from the government's point of view, first, expelling the intruder from the system. Second, building back better, to coin a phrase, for better cybersecurity defense. And then third, the response activities which are being considered in that context. But yes, you're right. It's the prosecution is only one aspect of this. And again, prosecution is important from the restorative justice, but it also serves, we hope, the deterrent function that will make, in this case, hostile state actors and those working for them think twice about future activity. But will also have the effect of, in some cases, allowing us to make sure that justice is done in a particular case.
Thank you, Bruce. We have a question from a Jackson student here about what we're seeing about non-state cyber criminals. They're asking about DOJ's approach, but I actually thought, Richard, it might be interesting for you to comment from a perspective of the Digital Crimes Unit. Have you seen any trends in non-state cyber criminal activity that are noteworthy in recent years? Are they growing more sophisticated? Are you seeing the tools of nation states, proliferating to non-state actors? Are there any sort of things that jump out to you in your experience with non-nation state cyber crime that's worth noting?
It's interesting. That's a great question, because I see the opposite. I know I've been dealing with the crime for profit model way back since, as I mentioned, 2008, 2009. And the level of sophistication on the crime for profit, the traditional cyber criminals, has increased dramatically. They went from simple IRC chat type bots to everything's encrypted, to everything's now dispersed internationally, making it much more difficult to take their infrastructure down. They take advantage of all the different jurisdictions, the different laws, the same issues that DOJ has that we have to work around. And we were able to do so very successfully in TrickBot because of the way that we've kind of set up an automated abuse and notice system that sent out these abuses automatically the minute something would pop up, as a result of the crawlers that we were able to stand up, and we're very effective. And to this day, we're still doing that. We're now seeing, I think, a merger of both cyber criminals and nation state. I think that the techniques that we've seen developed over the course of several years by cyber criminals, we're seeing them being utilized and leveraged by nation states simply by looking at the way that the infection vectors, looking at SolarWinds, as I mentioned previously, how they now infect broadly, and then they go back and they scan the computer systems to identify what target they want, either because it's a high profile target from a nation state perspective, or because it happens to be a hospital that would have to pay immediately if they get hit with ransomware. So I definitely have seen a merging of the two, but actually I think that the sophistication really began on the crime for profit side.
Thank you, Richard. Bruce, we have a question here from another law student about cyber attacks affecting physical infrastructure. I'm thinking in particular about the recent cyber attack against the water treatment facility outside of Tampa in Florida, which may have actually, potentially could have poisoned thousands of people. But just without commenting, of course, on any ongoing investigations here, can you give us a sense of how DOJ might think of, prosecuting, investigating certain types of activity that move beyond, either traditional espionage or for-profit, cyber theft, to affecting the physical infrastructure that could potentially have, human life loss? Does it involve a different type of calculus, in your view, a different set of actors? It just might be helpful for us to think a little bit about that.
Absolutely. I think that the key to all of this is, as you say, conduct that violates norms that we would expect. Again, if that kind of conduct attempts to affect infrastructure took place in the real world, we would expect that there to be criminal consequences. So we obviously do take that very seriously. And I think we've shown that our intention is to prosecute violations of that kind of those kinds of norms in the virtual world, no less than in the real world. So we've taken it outside the context of economic espionage, announced charges against Russians late last year, engaged with malicious cyber activity as well. So these are the types of actions where we will look to make attribution and to ensure that the actors know that they cannot expect to remain anonymous and engage in that type of threatening activity life-threatening activity. So that I speak, of course, generally not about any particular case, but that's our position.
Thank you, Bruce. We have 5 minutes left here. We'll see how many more we can get with. Just to you, Richard, we have a question here about encryption and the extent to which you have or haven't seen that hindering your access or your cooperation with law enforcement authorities, as well as a question from a Yale alum who's sort of noting that because of supporting GDR and other requirements of privacy regimes around the world, the companies find themselves moving data and sort of broadening the attack surface or vulnerability surface to cybercrime. Is this something that you have witnessed or become concerned about, or any advice you might have in that area?
Let me talk about the encryption piece first, because I'll talk about the encryption piece from our perspective and how it impacts our investigation. And I kind of noted earlier that, IRC chats, everything was open. Early 2009, 10, 11, 12, boom, everything's encrypted. Now, it's made it much more difficult for us to analyze malware because the packets that go back and forth are encrypted. We don't know. So one of the things that we're proud of, and that the engineers have spent considerable amount of time on, is how to get around identifying whether or not, hey, this is in fact malware X or malware Y, when you're looking at trying to map out the right infrastructure. And so the encryption problem has led us to develop different techniques as to how to take a look at these transmissions, because there are things that you could see and you could then kind of identify without ever looking at the content. So it takes much more time, they're much more sophisticated, and unless you have the private key, you don't have it. And that's really the big question mark. When you're doing these investigations, even from a law enforcement perspective, everything's encrypted unless you have the key. If you're able to find the server and they left the private key on the server, that changes the whole ball game. But then you're going into content, which is really something that you need the appropriate legal authority, which is really a law enforcement function. From our perspective, we've been able to get around the encryption problem by other technical countermeasures that's increased the time it takes, but it has not necessarily increased the efficacy of our operations. In terms of moving, data centers all over, that really is, to put it mildly, beyond my pay grade, and that is it was more of a business function as well as a regulatory function, and I just don't have the requisite information as to comment on that.
Thank you, Richard. Bruce,
Ted, I would certainly say on encryption that is a highly significant issue. Again, not simply with respect to cybercrime per se, that is crimes involving computers, but with electronic evidence across the board, and one that we and counterparts around the world are wrestling with how we go forward. Of course, we recognize the importance of privacy, but it is still an essential issue to work through in this regard. The other thing I would say, just quickly on moving data, yes, we do recognize the issues presented there. I mentioned the issues of just access to data, not just by the United States, but our counterparts. But I would say, I'd be remiss if I didn't point out that one positive development is that we do have an umbrella data protection agreement between the European Union and the United States that does indicate really basically a safe harbor for law enforcement information passed back and forth between our countries. And as one knows, from as I've said before, 4 of the happiest years of my life were spent negotiating that agreement. So that is I think a landmark showing that we can reach accords with respect to data protection. And we need to do that to make sure that doesn't prove to be an obstacle.
Great. Thank you, Bruce. I'm going to resist the urge here to ask more questions, just given where we stand on the time. I'm glad we were able to answer slightly more than we have left remaining, but the fact that we have so many just underscores how great a conversation this has been. So I want to kick it back to you, Ona, and obviously I hope folks will join us not just in thanking Bruce and Richard, but in the 3rd session of our forum in 2 weeks' time. Ona, any other final thoughts?
Just want to say thank you so much, both to Bruce and to Richard, for this really fantastic conversation. I think we've surfaced a lot of really difficult and interesting issues. There's no way to get through everything in an hour and 15 minutes, but we managed to get through a lot of it. So really grateful to both of you for that. And as Ted mentioned, our next session, 2 weeks from today, same time, is on the topic of defending forward, implications for safety, security, and sovereignty in cyberspace. We'll be joined by Colonel Gary Korn, who is a director of technology, law, and security program at American University, and Suzanne Spalding, who is senior advisor for Homeland Security at the Center for Strategic and International Studies. And they're really going to be digging into some of the national security pieces of this, sort of how do we respond to the kind of national security using national security tools as opposed to criminal tools, to criminal law tools. So that's the next part of the conversation. I hope you all will join us, but thank you again to our panelists. We're so grateful for this rich conversation, and thanks to all of our participants for being with us here today.
Great.
Thanks, everyone.
Take care.
Thanks so much.
Goodbye.
Thanks for having us.